and welcome to Senior Happenings. My name is Trisha Ayers, and I will be your host today. And I am so excited. I know I say that every time, but I really am so excited for our guests to be here today. We're talking financial and we're talking legal. And I get the pleasure of working with these gentlemen all the time because one of them is my boss and one of the person is adapted into our office, and I'm very excited. So we're going to introduce Mr. Todd Whatley, who is a certified elder law attorney, and Mr. Weiner, who is a certified financial planner. Welcome. Thank you so much for coming.
Thanks for having us.
I get to hear you guys in the office all the time and the radio show that just finished and the podcast that you do. And so I'm excited to bring that to my show. And then we have exciting news afterwards too. So let's go back to basics. Certified elder law attorney, what is that?
Sure. So I am a specialist, and not all lawyers can say that. They're actually very specific about that. The American Bar doesn't allow attorneys to say that they are a specialist unless they have gone through a very rigorous process. And I have gone through that process for elder law because it is so complicated. It is so it's tedious. There's a lot of laws, a lot of things that play into that. And so I've gone the extra length to go through the process, 5 years of practice. I've seen the requisite number of people, and I took another test, kind of like the bar exam. Pass rate is somewhere between 30 and 50% typically. So took that test and passed, and now for almost 20 years I've been a certified elder law attorney. There are only about 500 in the country. There's only 4 in Arkansas.
Wow.
Yeah.
And you trained all the other ones, right?
Pretty much.
Let's
I
just
can say
add
it.
that in there, yes. Ian, certified financial planner, what does that mean?
Similar specialty there a little bit, and similar education level. So there are, in anyone's financial life, there are a handful of different areas where that money touches. And so most advisors are focused on typically investments. That's mostly what we see. A certified financial planner is going to take into account cash flow, insurance, investments, retirement, estate, taxes, and bring all of those together in a comprehensive way, because things are much more dynamic than they maybe used to be. And so we're really big about specialization. And I think a good analogy for folks is that they're used to in their normal life is physicians. A lot of physicians are specialists, and a great physician is going to refer someone to a specialist in an area that's outside of their comfort zone. And so while we can do a lot of general practice things, we really specialize on the period of time in someone's life when they are getting ready to retire, getting ready to transition assets to the next generation, or they're coming up on the last third of their life.
Sure.
And these are big, important issues, and it's worth getting them right.
And in your office, Todd, the big documents, and I want you to get on your soapbox a little bit. Wills and trusts.
Me?
Yeah.
Have soapbox?
Yeah.
So, yes, wills and trusts. The common thing, I think August, we are coming up on National Will Month, which is the biggest disgrace in America. Not the biggest, but it is a huge disgrace that wills are what take you through probate. I think everybody pretty much understands, and particularly in Arkansas, you should understand you don't want to go through probate. Probate is public, it's expensive, it's time-consuming, and our goal, and I think every attorney's goal should be to keep people out of probate court. Probate court is when something goes wrong. And if your sole estate planning tool is a last will and testament, if you went to a lawyer and said, I need to plan my estate, and their only recommendation was a last will and testament, I will say it, you did not get good advice, okay? I am very bold about it. That is very strong, because particularly if you don't have minor children, you should not go through probate. And it's very easy to avoid. Probate is for something that is stuck in a dead person's name. So if you die with your bank account, your house, whatever, just in your name, no beneficiaries, no co-owners, it's stuck, and the only way we can get it unstuck is to go through probate court, and that's where we submit all of your personal financial stuff to a public record, and it's argued in public, and it takes time. The judge is very involved. It's just, you don't want to go through probate, and it's so easy to avoid. A lot of people in our office will do payable on death beneficiaries. And when you go to a typical attorney and say, I want to do estate planning, it's like, okay, hopefully they don't recommend a will, but some attorneys will say, okay, yeah, let's don't do a will, but you need a trust. Let's do a trust. And not everybody needs a trust. That's the other way we do things differently, is we meet with our clients. We definitely want to avoid probate, but there are simple ways to avoid probate. Payable on death beneficiaries on your bank accounts. You can do a beneficiary deed on your house. You can make your stocks payable on death. You can make everything instantly pass to your heirs at the time of your death if you do that correctly, and that's what a lot of our clients do. Now, sometimes that doesn't work for people. Sometimes their estate is complicated, and another pet peeve is, oh, well, I don't have enough to do a trust. The amount of your stuff has nothing to do with needing a trust or not. It's the complexity of what you want to do with it. If you just want to leave it to your kids free, just here it is, payable on death works for you. And for an attorney to talk you into doing a trust just to simply leave stuff to your kids, I think is malpractice, okay? It's not in your best interest. But if you have some complexities, I'm concerned about how this kid's going to spend money. I'm concerned about them going through a divorce or bankruptcy or a lawsuit, or I want to leave money to my grandkid who's 10 years old. Well, you can't leave money to a minor without causing all kinds of problems. And so with some of those complexities, a trust is what you need. And in our office, you tell me the payable on death doesn't work. I have some complexities that I need you to fix, and we do that with a trust. And so a trust it owns the property, so therefore it's not in your name at the time of your death, and therefore it doesn't go through probate, okay? And with the trust, we can do all those cool, complex things that you want done in the document. It stays out of court, it's quick, it's efficient, it's a beautiful tool.
Okay.
There's a lot there that I want to unpack.
Okay.
Unpack some of that for us, Ian.
And so I think there's a bunch of key issues that we talked about, and there's another big one that I want to talk about POAs too. I want to make sure we hit that.
I'm getting there.
Okay. I know you're on it. You're always on it. But I want to really frame the issue. Sorry to be the financial guy, but the cost of probate in Arkansas is exceedingly high. Mm-hmm. It's higher than I think most states. It's anywhere between 5 and 10% of someone's estate. Mm-hmm. So I just want to make sure that I say that slow enough that people can digest that.
Right.
So that includes real estate, that includes life insurance, that includes IRAs, brokerage accounts, anything that is stuck that has to go through probate, anywhere between 5 and 10%, depending on the total value of the estate. Yeah. That is an extraordinary amount of money. Oof. And if Todd, like you said, and I fundamentally agree with you, if an attorney in Arkansas recommends that you use a will and you don't have minor children as the estate planning tool, why might that be, Todd?
Well, probate is very lucrative for attorneys, okay? To go through probate, you really do need an attorney. And
at least in Arkansas.
Yeah, in Arkansas. And part of that 5 to 10%, I would say almost half of that fee is attorney's fees.
Set by statute, right?
Right,
By
it's
statute.
set.
Yeah. So you have a $100,000 estate, which is almost nothing nowadays. That's between $5,000 and $10,000. And so when you go to an attorney and it's like, hey, we're going to charge you $5,000 to do a trust, but we'll do a will for $350. You're like, oh, $350.
Sure.
Well, at the time of your death, with a $100,000 estate, you're going to pay somewhere between $5,000 and $10,000 to get it to your kids. Well, hardly anyone has a $100,000 estate. I mean, start doing $500,000, $1 million. When you do $1 million estate, which, like Ian said, the value of your houses have gone up tremendously. Life insurance, you add everything together. A lot of people are between $500,000 and $1 million, and that's at 5%. That's $25,000 at least.
Right.
And yeah, you save some money by purchasing a will, but one of our phrases that we love is save a buck and lose a fortune. Yeah, pay me $350 now. That's cheaper than those old lawyers down the street who do trusts. But then when you die, your family's going to come back to me, and I'm going to get to charge $15,000, $20,000, $30,000 to get this to do what a trust would do.
But you're right, there's that misconception. I know
This is a huge concern.
people think if they've got a will, it's taken care of. Everything going to go directly.
Yep.
I mean, I've heard it, and you have heard it.
All the time.
And the reason that we're so passionate about this is because you don't have to pay that much.
Right.
There's a better way that's simpler. And so, we're framing this conversation in the hopes that the one or two people out there that are listening, they're like, oh, that's what I was told, and I feel comfortable.
Right.
Like, we want to make sure that we can save you money. And it's a big deal. I mean, this is not simple stuff, and it's not unimportant stuff.
Right.
I mean, this is what you want to happen with everything you've accumulated through your entire life. I mean, these are meaningful issues.
Talk about the beneficiary deed, because
Okay.
I think that is super cool stuff that when people learn about that, they're like,
Yeah, it's amazing. So
yes.
most people, their biggest asset is their home. And particularly in Northwest Arkansas, it's gone up tremendously over the last 5 years. And if that's really your biggest asset and we want to avoid probate, then we can do one deed, a deed that is called a beneficiary deed that says, if I own this house at the time of my death, it goes to my kids or whoever that you put on this deed. You still own it. You can still borrow money on it. You can still sell it without anyone's permission. You can even change your mind on that deed, which is, to my knowledge, the only deed you can change without the person that you gave it to signing off on it. So if you leave it to your 3 kids and one of your kids goes bad on you and it's like, I don't want to leave it to them, yeah, we can change it and just leave it to the 2 kids. And the last deed that is filed is the one that wins. And so therefore you can basically disinherit a child and make sure this house goes to those 2. So it's flexible, it's revocable, it avoids probate. There's some tax issues of owning your home until the time of your death. If an attorney tells you to deed your house right now to your kids, that is horrible advice for a lot of reasons, but there's a big tax reason, particularly in Northwest Arkansas. There's a huge tax hit that you're going to, dump on your kid by giving them your house now. This deed, a beneficiary deed, does not give it to them now, but it says, if I own this house at the time of my death, it goes there, and there are huge tax benefits to that. And since 2019, everybody knows you can qualify for Medicaid and still own your home. The reason they let you do that is Medicaid wants to put a lien on your house and get all their money back. So if they've paid $40, $50, $60, $100,000 for your care in a nursing home, sure, we'll let you keep your $500,000 house because we know we can put a lien on that house and get our $100,000 back. The beneficiary deed avoids that.
Ooh.
Since 2019, the Arkansas legislature, with some pressure from us elder law attorneys, said, hey guys, make this so that Medicaid can't put a lien on it. And so since 2019, now it avoids the Medicaid lien. So it is the perfect tool, and it's $500, okay? It's a deed, $500, you can change your mind on it. It's just the perfect tool.
So everybody needs a beneficiary deed on their home.
That's a
Really?
very broad statement, but yeah, pretty much. I mean,
It's hard to, there are very probably rare exceptions to that.
So let's talk about trust still, and quite a unique thing in our office, I think, which made no sense to me, that why is not a financial planner involved in trust discussions?
Sure.
Because it's about money most of the time.
Well, and you brought up another issue, which is a tax issue, and I think that's something that we need to address. Of how do we do things and how we approach things? Because I think it's really unique.
Well, yeah, up until the last year, I've been doing this 25 years. So for 24 of those 25 years, I will meet with people, and as an attorney, I'm addressing their legal issues. Well, but legal issues are a portion of the pie. There's a whole other portion of this pie that's financial stuff. And I have begged and pleaded and tried to work with their financial advisor to say, here's what I'm thinking. What are you thinking financially? How does this all play together? I never could get them to the table because I was like intruding on their stuff, or I may recommend something that will cost them money, or I've just never been able to work with financial advisors very well to get them to sit at the same table with me. Or even if we did work together, it's like I would say something like, okay, well, I'll call my financial advisor, and they'll call, and 3 weeks later they can get an appointment, and they're like, okay, and then they call my office, and 3 weeks later they come see me, and it just takes years to do this. I met Ian, we started doing the radio show together, and I'm like, dude, I need you in the office with me. And we literally sit at the same table with people and say, okay, here's your legal, he's talking financial, and sometimes we go back and forth.
How they work together. I think that's what's so important, though, is these issues are not separate, and they're treated as separate.
Oh, absolutely.
And that's a really big problem, in my opinion.
And sometimes I'll recommend something, he's like, no, Todd, let's do this. I'm like, well, hang on a second. What? And so we're, the poor client's sitting there going, well, and we're having this very high level discussion of, but if we do this, this is going to happen. And that conversation that we do in 15 minutes would probably take 2 years going back and forth between professionals who don't sit at the same table. And so in a 1 hour meeting, we can come up with some amazing solutions to fix not just legal, but also financial. And our clients walk out of the office saying, man, I feel so much better that everything's taken care of.
Right.
And that does not happen in hardly any other law office, I would say, in the country.
Right.
I mean, I think we are pushing this nationwide to team up together. The American bar is real particular about people, like us being owners of a law firm or owners of the same thing where we're given the same. We can't do that yet. It's changing, but we've got it fixed so that people understand I do legal, he does financial, but they agree for us to sit down together and do this as a team, and they love it.
And we each have a fiduciary obligation separately to the client. I think that's something that's really important to understand.
Yes.
And so, I have an obligation to a client to do only what's in their best interest.
Is that all financial planners?
It is absolutely not. And
Okay.
that is part of the reason I wanted to talk about it just
Okay.
very briefly. Because I'm a certified financial planner, there's a really, really high ethical obligation that most advisors don't actually have.
Okay.
And most of them will say that they do. I actually heard recently from a client who said that their advisor said that they are not a fiduciary, which is the first time I've heard that. Which I credit them for saying that.
Yeah.
They don't always have to act in the best interest of the client, which is shocking, I think. But we have a separate but fiduciary obligation to the client. And so the way that I think about it is, I get the picture of a horse with blinders on. If they're only focused on this, they're missing some of the other stuff. We can cover pretty much everything and miss blind spots when we work together. And I don't work for Todd. Todd doesn't work for me. So we have no obligation to be a yes person to the other one.
Mm-hmm.
And I think people wouldn't think of that normally, but framing it in that way is really helpful because together we both have to come up with the absolute optimal solution for the client, and it will be unequivocally in their best interest and the least expensive option.
Right.
So we think it's really cool. We
Right.
think it's pretty dynamic, and clients love it. And sometimes we disagree in meetings a little bit of how to approach something. But there are other times where, like we had a meeting a week or two ago where, I kind of had this slightly crazy idea, but it ended up being a really good solution for the client. We were able to save taxes, get the parent qualified for Medicaid, and really optimize it in a way that we probably wouldn't have been able to do before.
Yeah,
So
absolutely.
And I know that you do a lot of speaking events and you do the radio and podcasts. And I think, in essence, I want our audience to know that you are pushing hot buttons and bringing stuff up. So if folks have people in place who they trust, go back and ask more questions. Mm-hmm. Go back and ask a lot of questions.
Mm-hmm. And we're a little bit unique too in the way that we work, and this is a longer conversation. I'm sure we'll talk about it more. But most financial advisors are only focused on primarily one thing, either insurance or investments.
Okay.
I'm a planner, and I approach it a little bit differently. And so we look at their assets, their wealth, a little bit more comprehensively than most do. And so we take everything into consideration. And so there are some clients who we will actually work with their other advisors if they want to maintain those relationships. And I kind of come in as the quarterback. And so I'm directing things and making sure that everyone is communicating. They've got A players that are only acting in their best interest, and we're communicating and collaborative together. And when I say that, people go, oh, that's so obvious. Why haven't we done that before? And I don't know that there's a good reason. Besides the fact that most professionals try to guard their stuff because they don't want to have someone else who's a professional looking at it, because I think they're afraid that they might not have been doing the right thing the whole time.
Okay.
So I'll leave it there.
Okay.
But we do have a very unique approach, but we're able to solve these challenges. And I think what's interesting about our approach is that we don't come at it with a preconceived idea of what the solutions or the tools need to be. What we're trying to do is get our clients to really kind of dream and go, what would I like to happen? Mm-hmm. You know, if you, sometimes Todd will say this, if you could wave a magic wand over everything in your situation, what do you want to happen? Our job is to put all the pieces and the tools together.
Try our best to do that.
But that's really what this should be. Mm-hmm. You know, what do you want? How do you want your assets to transfer? How do you want the rest of your life to go? And how do you want even, you know, things to go for the next generation if that's
Right.
important to you?
Yeah.
Let's talk about POAs.
Yeah.
Yes.
Because I know it's very
That's a big
important.
piece of
It's
this.
a huge piece. And what is a PO? What are POAs? How are they used?
Sure.
When do they cease to be used?
Okay.
And who are the best people to be designated for your POAs?
Well, one of the things I like to, and when I dress up for the office, obviously I don't dress up a lot, and I think it's in the client's best interest to never go to court. Okay, court is not in your best interest. Okay, and it is my goal to keep my clients out of court. The two courts that I want them to avoid is probate, and we just talked about that. The other one that you may not think about, but is pushed by medical and just people all the time, is guardianship. That is when a person becomes incapacitated and they can no longer function and do what needs to be done or protect themselves. Then we have to go, if nothing else is done, we go to court, prove in court, open court, testimony by different people to say this person's incapacitated, they can't manage their affairs. We're going to take away their rights and give those rights to a guardian who will now do what needs to be done for this person. It's court, it's open, it's expensive, it's time consuming. You have a lifetime commitment for the older person that's had the guardianship done against them. There is a lifetime commitment with that court. Every year you've got to submit things. And doctors and social workers are like, oh, they have dementia, go get a guardianship. It's just the thing to do. And it's not. And it's easily avoidable, just like a will takes you through probate. We can avoid that. To avoid guardianship, you have to do a power of attorney, a financial power of attorney and a healthcare power of attorney. And that is a legal document that says, I choose someone else to be my agent. Like I could say, I choose Trisha to be my financial power of attorney. I don't lose my rights. I can still practice law. I can still do things. But if I appointed you and I'm out of town on, as you said, my 4-month it's 2 weeks, by the way. But anyway, when I'm on vacation in Italy and the bank calls and needs something to do, I could say, hey, Trish, go to the bank and sign this for me. Or, hey, someone's taking money out of my account, go to the bank and figure this out. The bank will now recognize you as basically me as a legal authority to do something on my behalf. And if I were to become incapacitated, we don't have to go to court because the legal mechanism is in place for you to do things for me. You have to do this while you still have capacity, and that's a whole nother show. But it is crucial. You don't need to go to guardianship court, and doing a power of attorney avoids guardianship. And I think, as an elder law attorney, I think it is the most important document you can do because it allows us to avoid court, and then once you start getting a little bit of dementia, a little bit of crankiness and stubbornness and doing things, I've got someone to talk to handle your affairs for you in your best interest without you, since you can no longer do it, okay? It's just absolutely, and then there's the healthcare power of attorney. If you can't make healthcare decisions, you want someone out there who understands what you want. If you want every treatment in the world, fine, that's your right. Pick an agent that will pick every medical procedure that you want, but honestly, most people don't want that. They're like, hey, at the end of my life, and this is not just end of life, but at any point, I want someone that I love and trust and who knows me making decisions. And if you don't make it beforehand and we have to do a guardianship, a judge chooses. And basically, they're going to choose whoever shows up and is dressed nice and acts nice in court to say, I think you're the best person, even though they've been, and antagonistic to mom. They've stolen money from mom. They are not the best person, but the judge is like, you showed up today, you look nice, I'll pick you. No, you know who's going to do the best job. And a lot of people, and I do separate documents for financial and healthcare, because sometimes this person's really good with financial stuff, but I don't want them making medical decisions. I want this person making medical decisions. And so you pick and you choose. It's what you want, and it keeps you out of court.
Ooh, is it a good idea for me to make all 3 of my girls my healthcare power of attorney?
You have 3 girls.
They all have to agree together to do the same thing. They all have to
agree. It's just a nightmare.
So choose one.
And so this is where, and my power of attorney has a lot of powers in it. And if you have questions about this, if you want to see what those every power of attorney needs to have 9 powers. There's 9 things that a lot of attorneys miss, non-specialized attorneys. Like I said, I'm like your aortic cardiac surgeon, okay? I focus on one thing, and I will tell you there's 9 things need to be in your power of attorney, and if you download it off the internet, it's not going to be there. And there's a few of those powers that if they're not there, you could literally lose your entire estate if you need to go into the nursing home. With those powers, I can save almost everything. Without those powers, and sometimes it's one sentence in your power of attorney. If it's not there and you have to go into the nursing home, you could lose everything. But with that sentence, I can save everything. It is literally that important.
It's the little things. You could have 99% of the knowledge and even be able to apply it, and you could get a pretty good degree of the way in both of our worlds.
Sure.
It's that 1% that if you get it wrong with one line, everything explodes.
Sure.
And that's why it's so important that, we work together and communicate about this, but we also have to specialize and understand these little nuanced things. I want to ask a question before we go. Todd, it sounds like you're giving up your rights when you get a power of attorney. Can you address that? Because this is a huge misconception.
Sure.
Yeah. Everybody thinks, I'm not signing this because I don't want to give up my rights. No. My wife is my power of attorney. I still practice law. I still drive. I still do stuff. No, it's you're just saying, hey, world, this person can do stuff for me, okay? It's immediately effective, and it's just, hey, this person can do stuff for me. I still do stuff. I still sign checks. And so a lot of times with particularly the aging men, they're like, I'm not giving up my rights. I understand. No, you're not. You still sign this, and you're just letting your daughter or your son help you do stuff. You're not giving up anything.
It's actually ensuring that you keep those, because if you have to go through guardianship, you're definitely going to lose it.
If you don't sign this piece of paper and you become incapacitated and we do a guardianship, you do lose your rights. You don't vote, you can't marry, you can't sign a contract, you can't do anything. Your agent, your guardian is now you legally. You have no rights, but with a power of attorney, you keep those rights all the way up to the very end.
Well, we're just getting into it, and we have to finish today. I'm sorry, but great news. Todd and Ian are going to be doing a show on our channel. It's going to be called Generations Wealth Talk. We're going to have lots of guests, some guests, maybe. I mean, you guys can talk enough. Yeah. There'll be guests. They'll be talking about legal and financial issues. We can get questions to them, I'm sure. If you want to call the office, it is 479-601-4119. We'll put that up somewhere too for questions. And they'll be starting next month. Generations Wealth Talk. We're very excited. Lots of things to talk about. They really stir it up. And thank you so much for being my guest today. I appreciate it.
The website, generationslegalgroup.com.
Yes, that went by before there.
We're very proud. Trisha has helped me get the website up and going. So generationslegalgroup.com has got a lot of information. You can make appointments there. You can,
It's worth it to double check that what you want to happen is actually going to happen.
Right.
This is measure twice, cut once in action with everything you've saved for, everything that you want to happen. So let's just double check. Let's have a conversation and make sure that the things that you want to happen are actually going to happen if you leave it the way that it is.
All right. Thank you, guys. And we will see you next time on Senior Happenings. Thank you.